Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew.
And I think we can do it. We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side 2 minutes. We'll see how we do with that. And we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a
Welcome back, everyone.
juror questionnaire?
I know you asked us to. We haven't spoken.
All right, so today's the final trial conference where I'm supposed to have all of this, right?
Understood.
Can you do it before you finish? Well, let's see where we get with the motions, and we'll see about that.
And Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
It'll take me 30 seconds. I want the court to be super, super clear about this one point. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. On the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear, is
I understand what your point is in making
there
it.
was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure.
all right.
That's clear. Thank you.
All right, well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question.
Are we going to be pursuing third party?
Yes.
All right, so I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
This is interesting. Is he only having 2 minutes as well?
Jimmy, keep track, please.
Yeah.
Go ahead.
Thank you. During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point.
It's your job.
And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the
So
defendant.
I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See?
I've read your motion, I've read your memo.
Good.
Okay.
Or the pleadings.
Thank you.
All right, Mr. Yannetti? Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium?
Yes.
Thank you.
And he had 45 minutes easy.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in Trial 1. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary, it was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right, I appreciate your brevity, too. Thank you. Mr. Brennan?
Thank you. The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data.
So archive witnesses should be allowed in because they're going to testify to the exact same thing they testified to in the first trial. Dr. Russell should be allowed in. She's going to testify to exactly the same things she testified to in the first case. Is that how the rules are, Mr. Brennan? No, I think not.
They're in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different that hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Hit the likes for these decorated dudes. Thank you, Denny.
I like it.
Okay, thank you very much. I'll get a decision quickly to you in that. Does the defense intend to bring up any bad character or misconduct of John O'Keefe or any witness?
Witness, yes.
No, bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence if we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not during the opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before a week before the evidence starts.
Thank you.
M-Spire paying for any late fees in the future. I appreciate it, M-Spire. Thank you very much. And Danny T, hit the like for this gray goat. I'll take it. I'll take it. Appreciate you. Thank you so much.
Okay, that's paper 587, Mr. Clerk.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson. And it also includes a request to exempt from sequestration.
Your Honor, with regards to this motion, we have no, on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product, so any such offer of proof, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the appropriate time.
Okay.
Thank you.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to...
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from sequestration.
This guy is almost as annoying as DA Lally. Bright Bear,
More.
I wish we could have Lally back. He was a stumbling fool, and but he got jonesing for cigarettes after 30 minutes, so he didn't stand there and lie as much as this idiot does.
Okay. So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now.
Remember when he asked that, was it one of the EMTs, how long it took him to get to the station and clear the snow away? I think it took him 30 minutes just to get out of the driveway. He's such a bad interviewer.
Than when the Commonwealth filed it back on March 10th, right, with Michael Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it would be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of an advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to file? provide them?
They have a copy of everything that we got.
Oh, okay.
So we had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
The Brady list isn't a list. A Brady is it's a violation you can make. Brady is turning over exculpatory evidence, or in matter of fact, every piece of evidence. And he is a problem for them with the Brady list because he should have turned over the videos. And they can't hide behind, he hid it from us, because the Commonwealth bears the brunt of the Brady obligation for any members who has been connected to the case.
Okay, how much time?
Well, I think till the end of next week.
Is that the same timetable you would have whoever's arguing for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some, even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right, is this something we...
There is a list, yeah, there is, but again, it's more breaking a rule.
should come in the day before impanelment and deal with?
Oh, I hope she isn't too bad that you can come home quickly. And Hyacinth, don't have your mom around because you will be swearing like a sailor if you watch this morning.
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too, if there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay?
Does the superintendent have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
Sorry, I didn't know this was a Minnesota thing. I'm blocked, so I can't see it. But there is a Brady list in Minnesota. It's a definitive public-facing database of information about police misconduct. Thank you so much, Marissa. I thought it was just a violation you could make. I didn't know that, but he should be on that. So
interesting. Well, look at there. You tried to correct her, and you were wrong. Way to go.
I tried to correct the record, and there was an objection, misstatement of facts. There was a ruling, and Judge Darrow will come in and then say 45 minutes of why she chose to uphold the objection. I'm going to call Jamie and make her take care of Marissa.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Marissa is on a few lists herself, so...
Hey, shh.
Oh, yeah, only the wish list for Christmas presents.
Santa's nice list.
Santa's nice list, yes.
Can you
I'll move
have...
as quickly as I can. I have a lot of obligations over the next week. I'll try to facilitate it. I just don't know.
All right. Without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So...
Correct.
All right, so, Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed, and or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
See anyone you know on this Brady list?
A couple of them. Everyone with a picture, in fact.
Yeah, because these are pictures taken from the first trial.
Outstanding. Good.
Brian Tolley, Bukaki, and Michael Proctor. And
the trooper formerly known as Proctor.
I love when I saw it. It's the Giglio. I thought it was a Gigolo so you could hire them for fun times. Anyone you know on
There's
this
a couple
picture?
more familiar faces.
Yeah.
Ah,
Ken Mello, who is
Meatball.
trying Aiden, and Meatball Morrissey, who's a
Meatball
district
Morris.
attorney, and he's on the Brady list.
Wow.
Jeepers Cripes.
Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it, and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor, I appreciate that.
All right. So on the 1st, you'll tell me how much time you need.
That's wild.
Yeah.
All right, so
both
Mr.
lead
Brennan, since
investigators
we
on
are
the
making
case
good time,
is on
I'll let
the
you go back and
Brady list.
finish what you were saying when I gave you your 2-minute, when I cut you off after 2 minutes on third-party culprit, and then Ms. Tianetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Tianetti.
Your Honor,
Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're...
last time I said I wasn't excluding it, you just couldn't open on it. All right, so that's where I'm at this point, and I'll hear the different sides. So,
If that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, I guess I'll hear you on your motion on that then.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose.
Christine's been a member for 16 months. That's amazing. Thank you so much. And of course, free the fluffy.
I wasn't wrong. I corrected the record. And I've learned from Special Prosector Brennan, then you're right.
As a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview. Every witness. There is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present evidence, sometimes alleged prior bad act evidence, or
Except Brian Higgins, and then a tall guy with dark hair entered the room.
character evidence, is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at Sarbar fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third-party culprit is and what do they want to introduce. Do they have a witness? Do they have evidence? Do they have any records? Simply assailing people's character randomly is improper, it's unfair, and then it causes
Like you did with the entire defense team before lunch.
the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is, and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court, whether we think it is appropriate or whether we think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court and the courts have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence. They shouldn't have, they could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
All right, so Ms. Giannetti, I will hear from you, and I'd ask you to focus on, could you tell me whether This is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
It's the second alternative. In other words,
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's third-party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can you make an
It's still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
3, yes.
Okay, so can you tell me the 3 that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over here?
This is, in my recollection, the first time those 3 names were mentioned in open court.
I think in open court, yes. I think they've been mentioned outside of court, but I could be wrong on that.
They, I think they might have said it in an interview, one of those names, but not all 3. The names mentioned: Brian Albert, owner of Fairview 34, Brian Higgins, a guy who I find it very uncredible could have done it because he's such a duty-bound officer. He went back drunk as a skunk and still moved his cars at the police station in the middle of the night because he is just that duty-bound by his pledge.
Mm-hmm.
And Colon, who is the guy who always lands on his knuckles when he falls, who's never been in a fight in his life.
Except for the couple that happened to be on video that came out after he made that statement.
It's happened, I think in open court, yes, but those 3 make sense with the evidence we heard at last trial. Brian Higgins is clearly just like Julie. He's very salty and his bum chum helped him. So, no, they fell over and you always land on your knuckles when you fall in snow.
I've fallen a lot. I don't know how many times I've fallen on my knuckles.
Doink the Clown, a bum chum is, when you need that extra little money when you only have a roach left and you really want to have, instead of smoking some skunk, and you go down to the Denny's, go behind it at the dumpster, and that's a bum chum. Yeah, they are very agile people. Why was he on his phone? He comes back from sidebar. Does he then take his phone? Yeah. Why does he go on his phone?
Wonder who he's texting.
Yeah. Or who texted him really fast. Oh my God, they want to look in on it so bad as well. Yeah, I was just panning to the juror seats. Nice work, Lorne and Grimm. You saw it too. I'm smoke good weed, Broken Baker. This is why you'd be blocked forever. You wouldn't need those 5 extra trips to your bum chum if you would let me pay those $25. I'm just saying. Makes me laugh. They can tell you everything that happened up till getting home, but that doesn't deserve investigation. Well,
Right.
I always forget what happens when I enter my house. I couldn't remember what penicillin was called earlier today. I'm getting old. What's going on? They just mentioned there are 3 suspects in a third-party culprit defense. Not a surprise. Brian Albert, Brian Higgins, and Colon. But it's been mentioned in open court for the first time, we believe. I don't believe they mentioned it during the first trial who their third-party culprit suspects were. Well, Julie, I will use it from now on. Krusty will be tweeting Hank now. Doesn't she always do that? Colin's colon only has 20% ratio. Yeah, I think his colon puckered up real fast right now. Oh, he's just calculating his money.
That could be.
Did they go on? What? The defense team's huddled up. And what? I believe Hank and Bev just heard evidence of the 3 causing the murder, and Hank looked shook up. Let's go back and see when he comes back then. Let's see. Defense team huddles up.
Aaron's slams your desk down. They look defeated as shit.
Yeah.
They look like somebody just kicked them.
Yeah, he does look
All 3 of them.
deflated.
Yeah.
And nothing happens. Why are we still on break? Yeah, it's OnlyFan. The OnlyFan you need. Yes, the defense team presented evidence at sidebar because they didn't want to state it in the open, which is reasonable enough. So they went to sidebar. And they were at another sidebar. So they went to sidebar to tell
Defense
why.
has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's
I think Brandy
motion
was
in
the one
limine
who
to exclude
named
the
it
expert
OnlyFans.
testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
She already had her midday lunch. We had an hour lunch, a 20-minute break, and we are going to end in 27 minutes.
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand up?
2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
I can only speculate that he looked, the way he sat down and hunched over, but again, now I'm doing Dr. G level of body language interpretation, but maybe he just always looks like a wet dog. I don't know. We don't know what's said. We can only speculate.
It definitely looked like the 3 of them were walking back to their table like they just lost something huge, and the defense team looked rather excited. That was my perspective.
Yeah. Sorry, my godfather passed away. Oh, I'm so sorry. My condolences. I'm cleaning his house. We will try and distract you, and always ask questions if you have them. Then I can go into comments and hear you talk too much. It's a commentary channel.
State looked defeated.
State looked defeated.
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question, but that's the purpose, is to to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying.
You've turned over evidence.
He did not.
You turned over evidence after discovery deadline.
Today, he had some discovery he was supposed to present today that he didn't bring.
How can you be this retarded? Sorry for those who don't like people using this word. It's not to disparage people who suffer from retardation, but this guy should be clinically found retarded. Jesus Christ.
Deal with it, so I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes, thank you.
All right,
Thank you, Your Honor.
thank you. So 6:07, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th. All right, the Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figure this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments, and essentially...
So the same thing you're doing with your biomechanical engineer that you said that, no, it's fine.
Literally the exact same thing.
This guy isn't even trying to put a square peg in a round hole. He's using exactly, if it's a round hole, he will claim it's square. It's not even the peg that's square, it's the round hole that's square. He's such an idiot. He uses the same arguments against the defense that he claims doesn't apply to his witnesses.
Well, he's special. He's the special
Easter is
person.
a former FBI agent, not as highly trained and decorated as Caffey Daffy, who is, but who does forensic examinations and is there to say, this was bullcrap, Your Honor.
Summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be.
No, it would be the same as an expert in police investigations coming in and giving his professional opinion about how this investigation was led. There's a big difference.
What it is.
It's not a YouTube idiot grifter from Denmark who comes in and says, that's retarded, using solo cups. Have you ever heard something that stupid? No, this is a real FBI agent, not a Caffey Daffy, the porch pirate. Come on now.
That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules.
He did instruct in best practices because he was an instructor. But again,
and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And the witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to stop by telling me what you expect him to testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an expert on it? Is it something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material that you can share with me?
Sure. I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to, or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is it all, is the basis of his testimony just crime scene, like collection of evidence, or is it
Witness
when
interview.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too. Both. Because if someone tells you as an investigator someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side, they're nearly word for word. And the advisory committee notes for federal rules of evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners, testifying to land values. Now again, obviously we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the Rules of Evidence 702, the Federal Rules of Evidence 702, clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally.
Well, I'm not flying to Massachusetts sitting in a hallway. I will ask Jamie if she'll do it. You will have to pay my medical bills when she beats me up.
He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either, what I was reciting is either in the CD or in his report.
Okay, so that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like from me.
So I wanted to know specifically what you intend to have him testify on, but if it's in his report...
It broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review, he's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative
So I guess that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowden defense, and he is the primary expert that we would use to propound that Bowden defense.
All right, can you get me that report before you leave? Do you have it extra?
I think we probably have an extra copy of it, yes.
Mr. Brennan, did you want to respond?
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowden. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury they should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the the Canton Police Department again and call in the state police for a second round so they can explain why they show certain actions that Mr. Easter is criticizing? I don't think this is a...
I think you really, really should call them in and tell them why they didn't follow procedure. Because Bowden is the they didn't do shit defense. And then you can rebut that and say, we did shit. But the problem is, you didn't. You broke every procedure. Anyone who watched Matlock know your investigation was bullshit. Sorry.
You're not wrong.
No.
No.
Well, Marissa will tell me in a minute I'm wrong, but...
an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden-type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic? That everybody did it.
Oh, they should. They should. And then, because then you can cross-examine them with the state police procedure list that's written down, probably stating you cordon off the crime scene, you secure evidence, you have an evidence log. Yeah, let's get someone in to testify. No. That's totally. Let's get Chief Rafferty in to testify.
I like it. There's no way any state trooper with an ounce of integrity would get on the stand and say that this investigation was done properly. There's no way. None.
Well,
you might get like Trooper Paul or Bukaki.
The wind was blowing, so it's impossible to put up crime scene tape.
Right. Oh my God.
I don't think he even knows. I don't think that the thought hits his head and then his mouth starts opening. I think his mouth just keeps going and then his brain catches up and says, what the hell am I saying?
Trooper Paul would get on the stand and be like, well, the crime scene told me not to put up the tape. And that was...
the crime scene tape made me look fat, so...
Remarkable job under the circumstances. What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a
That's absolutely not what this is inviting. Why are you always lying, you stupid...
debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom.
We will... He realized his first analogy didn't come across the way he had hoped. He was like, oh shit, I really don't want to do that.
I need to find a new one. That's when his brain caught up with his mouth. It was like, shit, this is stupid.
That was a bad argument.
An opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
Your Honor, very briefly, I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
you wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
Please.
Do it. I'd love that. I'd love a shot at that.
Okay, so I said let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm saying do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we're entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within...
I don't know. So if you can give me a case site for that, all right?
It's literally in both.
Expert testimony regarding a Bowden defense. I've never seen it. I've never seen it in research or anything. So I'd like a case site.
There are certainly cases outside the jurisdiction.
Yep, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts, to my finding, to our finding, there isn't one directly on point, but there's a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout
So
the country
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this, okay?
Sure.
All right, so I think that's it for the motions in limine. Did I miss anything?
Jemima, did you miss anything?
All right.
Well, better
need
find a
that-
Supreme
oh.
Court case.
Your Honor, earlier you alluded to, this is what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll wait for it. We'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't, we have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions.
Right.
If in addition to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment, it makes sense to me.
Oh, I'm sorry, Your Honor. I was okay.
Were they the same as Morrissey? Because that's only for impeachment they weren't allowed. I don't think they have.
I don't think she wrote
I don't think they've talked about other than no objections. No. I don't think that it's been.
Outside case, no, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the party.
What the hell?
Okay.
And she wasn't talking. I think. Oh,
Oh, I'm sorry, Your Honor. I was okay. For outside cases, no, there's no objection.
All right. So I need the joint questionnaire, and it can be the.
no, it just went away.
Hey, Bush, how you doing, buddy? Good morning.
Yeah, Brendan thinks that the family, the Alberts are family. Yeah, Chloe is chewing on the wire.
Yeah, I got a super chat.
You got a super chat?
I did. M. Spire says, why don't dumb lawyers ever play hide and seek? Because good luck hiding when they keep shouting objection every time someone counts to 10. For real. For real, M. Spire. Thank you so much. I appreciate you. So what are we thinking here? You think it's done? Think they're just...
I'm trying to go on the Twitter to see if anyone...
Maybe Brennan pulled the plug because he was tired of getting spanked.
Yeah. Could be... Boston Brandy is asking a good question. Is making fun of an attorney not considered misconduct when it's being done by a judge? How rude is Judge Canoni towards Robert Alessi and a constant interruption? So glad Janetti made it clear on the record that she's yet again doing it.
That's funny. Oh yeah, Turtle Boy wasn't there either, so he can't tell us.
Captain Twathead speaks for the first time since Reed calling a DUI lawyer after Proctor told her she was going to get charged with DUI is a sign of guilt. Oh yeah, that's Captain Twathead is the female prosecutor.
Wow.
Ted Daniels, the last thing. Judge wants a jury questionnaire related to pretrial publicity. What prospective jurors have seen and heard? done for the day. Next hearing is Tuesday, the 25th. So we are diggity done.
So that's it, huh?
That was a long day. Almost
Bev,
4
yeah.
hours.
Yeah, that's crazy long.
Um,
She's probably going to need a mental health day off tomorrow. She worked too hard.
This day was stupid. What did we get rulings on today? Motion to move the trial was not granted. No ruling on the buffer zone.
Which she's going to move. She's going to push it out further because that only
but
helps the Commonwealth.
if it's 100 or 200 feet, doesn't really matter, or yards or whatever it is. Then they had that big talk about getting to mention that the feds were hired, the ARCA was hired by the feds, and then Hanky the Pooh lied again and said that they didn't look at all the evidence and that they didn't permit, they didn't do perjury, but didn't tell the truth. And then we are going to have a Rule 14 motion to talk about the relationship between the state and the, not the state, the defense and the ARCA guys. She denied spoken objections, which I think is stupid because it'll make the appeal so much harder because at appeals they'll just say, well, the objection was ruled upon, but they don't know if it was ruled upon because it lacked grounds or it was hearsay or it was repetitive or whatever it was. So that's actually a big problem. She won't decide on Crosby so far. No one can be in contact with the jury. Not the defense, through the media. Funny she had to yell that. She didn't mention that the reason why they said it was because Lally was seen eating with his witness while he was examining that witness on the stand. She'll wait to decide on sealing the sidebar. Commonwealth won't call their own Emmy. She is on the witness list, but Brennan says he probably won't call her, which is, in my opinion, unheard of, especially because I think he has at least 2 expert witnesses hired to come in and give testimony on the manner of death, but he won't bring the person who did the autopsy they rely on. I haven't seen that before, I think.
No, that's new. That's new to me. I've never seen something like that before.
Yeah.
We have an ME, but we don't like what she has to say, so we're going to bring in somebody else outside of the ME's office. That's weird. Yeah,
and we are looking at the pictures she took because she's the one who did all the measurements.
It's very bizarre.
The query on the juror, which is kind of a background check, decided later. Welcher, the defense believes he shouldn't be allowed because, again, he never proves his methodology. The case law says he needs to prove his methodology. He goes way beyond the scope of a biomechanic, and he's just being, it sounded like he was just being used to try and bolster the credibility of Jen McCabe. So he was going to be an expert about everything, which is not allowed. And then Brennan got up and said, well, he's not going to testify about the frozen ground. He's not going to testify about phone issues, but he knows everything about them. And he'll slip up and sadly talk about it, probably.
Of course he will. Of course he will.
So he made a 140-page PowerPoint that he won't use. Only a few videos from it. And no proof about how he did anything, and Brennan said, well, the ARCA guys didn't make any proof either, while they actually stated it in their reports. Brennan claimed first that the cards didn't touch, then he said they only slightly touched.
Slightly nudged.
Nudged, yeah. He has to turn over the redacted 140 pages of the updated 140 pages by Monday. The defense claims it's trial by ambush because they need to know what he's going to talk about. And then I wrote, Hank is a dingbat. Claims the defense doesn't understand science, says science and data a lot without why he says it. Claims the tail light scraped John's arm and keeps attacking the defense and talking disparagingly about them. Unless he stands up, spanks him, says he doesn't know anything and he's lying about the ARCA guys, and he never ever answers anything the defense raises, and he just shits on the defense. Chalks and demonstratives were allowed. They want to have the text to prove out-of-court statements by John to prove he was about to leave her, and then they want to bring in hearsay from the niece. There's no evidence he ever told Karen he was going to leave her. I can't read my own notes. Oh, it's just to tarnish her reputation. Again, Hank lied about the timeline, claiming that Karen talked to Jen McCabe on the way to Fairview 34 and heard Jen tell John that it was close to Samantha, his old girlfriend, but she never told Karen that till the next morning around 5:30. And I put in, the Ashley shit is so iffed, and he lied about the conversation. They don't want a Cellbrite presentation because it didn't prove what you did with Cellbrite. It was just going through that X whatever program that weirdo had made, and it's also against the law. And his argument was, we did it in the first trial, so it's good to go, which isn't the thing because it's a new trial. Remember, Meatball and the witness advocate will only be used for impeachment. Proctor, the Proctor thing, they want to see the internal investigations before they have an opinion about that. That will be next week. Third party, the Commonwealth don't want it in because no one said John was ever in the house. And then she asked, do you have third party culprits? And they said, and I believe it's the first time ever mentioned in open court, the Bribes and Colon are our suspects. We then went to a sidebar.
To make sure there's no confusion there, that was Brian Albert, Brian Higgins, and Colin Albert, just to make sure.
Bri.
Yes.
And Colon.
I want everybody to make sure they got the right names on that one.
Yeah, if you have your bingo card at home, I still think Higgins is the most likely to instigate anything. I think we will be watching a different part of the waterfall video this time around than we did the last time. I think we're going to see when he was standing in the corner pointing at him and being held back.
I bet.
I think they probably didn't notice it the first time, and it was first when everyone on the internet started to talk about that part that they felt confident enough to say it. They went to a sidebar because she wanted to know what evidence they had that could point to these three people. And again, I'm not Dr. G. I don't make up body language interpretations, but go back and watch it. There seemed to have been a different vibe after. The defense went into a huddle. We didn't really see them, and Karen was just sitting on a chair listening in. But go back and look at the state. And right at that moment, Hanky Panky either writes a text or answers a text. is it what it looks like to me. The cameraman did a good shot of it. Then they go back on the sidebar and comes back down again. And again, I don't believe in anyone claiming you can body language read anything, but they looked different. And I'll let you decide what you read it as, because I don't know.
Yeah, I
And
would have really
he's-
liked to have heard what happened at that sidebar. That would have
Yeah.
been an interesting one.
And the Easter thing, he's an FBI agent who was to come in and say this was a shitty investigation. Hank claims he doesn't have any knowledge about anything. He don't know his ass from a bike handle, and he has no right to testify. And the defense says, well, of course he has, because he's an expert, and it's the Bowden defense. Which the Bowden defense, for those of you who didn't read law like me and just Google it, the Bowden defense is it was a shitty investigation. That's why we believe she's innocent. So he should be able to come in and testify that it was a shitty investigation.
Oh yeah.
And
because
but
it
she
was.
she wanted case law proving that it's been done before.
We've seen it done before. We've seen it
Yes.
done lots of times. It's
And I love that. What do you want me to do? Call other agents? Yeah, do it.
Yeah, do it. Do it.
Do it.
Jackson, we were going to refrain from the. That wasn't a personal attack.
They stated today they weren't required last time to name the third-party culprit. Yes. But she asked today if you have, and he said yes. Brian Alberts, Brian Higgins, and Colon. Hank isn't a fan of all overqualified experts. They are really annoying, especially if they're not on his side. So
he's so bad.
It was a really interesting day. The defense have lost their shit with Bev. They don't care anymore.
And
they don't play
Brent,
nice anymore. They attack her.
They're tired of them both. They're tired of the whole thing. Alessi was getting so heated up. Yannetti was fired up. Jackson was. Everybody was mad. I love it.
Yeah, it was. There was a totally different vibe today than there was Wednesday. That's. I don't think you can. It's not even the same people. It's. They were ready to fight today.
Well, I think they made a decision that they were going to fight because it was all of them, right? It wasn't just Jackson losing his shit or Alessi losing his shit. It was the entire defense team was going after it. It's like, all right, let's play rough. Let's play rough.
And again, starting the day off with him trying to sneak around and get into Karen's phone that way, I think gloves are off and now we're going.
I think they're pissed. I love watching Alessi. He gets so fired up, and you can tell because he like starts hand picking his words that he's speaking because he doesn't. Oh, he's good. He's good.
I say the brother who saw Karen Reed alone in her vehicle with John O'Keefe nowhere inside proves John O'Keefe went into the house. Yes, that's been my assertion the whole time. That lines up with my belief of what happened because I don't speculate on who could have done what at what point. I just, and I'll claim this because this is what the trial is about, Karen Reed didn't kill John O'Keefe. But her testimony is, we arrived at the house, I park at the mailbox. He walks out, walks up to the door. I move forward when the other car is coming. And that's the last time I see him. That lines up with everything that happens after that in her perspective. The angry messages, the anger she had in the morning, and then the surprise when she finds her, because she believed he was getting drunk with his friends. And she was sitting outside, and as women do, got real pissy when he didn't come out. Because she was sick, she wanted to go home.
To add to the John O'Keefe being in the house situation, during the trial, they showed the first trial. They showed phone GPS maps of what they said proved he wasn't in the house. But if you get into the tech of that and how it actually works, it very easily could have proved that he could have been in the house. I pointed it out at the time, but it was a long time ago.
And again, there's so many misstatements from people who were in the house. There's so much shoddy police work going around what happened in the house that there's enough reasonable doubt that you don't have to say Colin did it or Chloe did it or whoever you want to say, because that's not that no one else is on trial here. I know there's a third-party culprit defense, so they are gonna point to other people and make the defense, make the state clear their names, but the overlying message in all of this is Karen Reed is innocent, and then you can go speculate who you think might have done it. Colonel Mustard in the abattoir with a candlestick, maybe, I don't know. Valhalla in a barn with a goat. Could have been, would line up with some of the injuries, but again,
Better than Alexis.
all of this crap we watched for 5 hours today more than proves to me this case will be worse the second time around, because they have even less to prove she did it.
It's going to be interesting. It's going to be wild, I think, because Brennan, he has got no moral compass. He's got no ethics obligations internally. Like he's
Lally would take his jabs, but Lally was never mean.
Right.
Lally was just a prosecutor who's been a prosecutor for too long, and they get that God complex. Brennan is actually mean, and he's actually claiming that the defense don't know shit. And you have the professional courtesy in a courtroom. You can imply, but he openly stated they don't understand science. To Alessi, a guy who could drive rings around you while you try to figure out if 2 + 2 is 4, and you claim he has no knowledge and no understanding of science. It was
Alessi impresses me. He impresses the shit out of me. Apparently, he was an Eagle Scout as well.
I don't know what. I know what a scout is. I don't know why Eagle Scouts are special.
So Eagle Scouts is like the top rank you can achieve in the Scouts, and it's typically around the time when people go to college that they finally achieve the Eagle Scout badge, and it's a very rare thing in Scouts. It's you have to do a whole lot to become an Eagle Scout. It's quite the accomplishment. Quite the accomplishment.
Oh, by the way, on the official record for this morning's hearing, it states defendant not in court. Yeah, because she wasn't alerted to be in court. Isn't that underhanded again? Why do you have
what did
to
you
do
say?
This?
They listed her as not being there on time this morning for a court case that she got yelled
Defendant
at.
not in court. Intervener Aidan Carney present along with his attorney Tim Bradle. Defendant enters while hearing is in progress along with counsel Yannetti Little, Alessi, and Jackson.
Wow.
So officially, she didn't turn up to her own hearing on time.
Wow. And then her lawyers all got yelled at for being there because it had nothing to do with her. And they still wrote it down like that. That's amazing.
Tell me the fix ain't in, y'all. Tell me.
Well, Tuesday, we will be back with this case.
Tuesday?
Yeah, the 25th.
Okay, cool.
Yeah. Tuesday, the 25th. Tomorrow, I will be doing the closing arguments in the snowplow pew case, because they have been going on today, are going on today. But I need to go hit my head into a wall again. Saturday, I won't be doing anything. Marissa is still trying to see if she can pull some strings for Sunday Karen Reed panel like the last couple of weeks. Well, she claims she is, but she's just eating chocolate and crying because one of her shrimps died. So we might do something Sunday. Saturday, no Stabby Day because I will be at the Baby Baker's house. Monday, I don't know. Tuesday, Karen Reed back on the menu, boys.
Cool. You got a super chat.
I know. Why is Bev concerned that the case law has to be in Massachusetts? Should be able to have a case law anywhere, right? She said I would prefer it is from Massachusetts because then she can say, well, it has been ruled on in this state and this state finds it because then there's a precedent in this state. But if they have 20 cases from, well, you can't have it from Arizona, it doesn't exist. But if you have from Oregon, Portsmouth, Virginia, Albuquerque, then you can bring that and say, we have 20 other cases where this exact same thing happened, so there is precedent that you can rely on. It's just so if there's nothing in Massachusetts, she will be setting precedent. So she wants to make sure that she's not coloring outside of the lines. Thank you, Mickey. Looks like the wall already beat the hell out of you. Well, I'm just old, but I'm still better looking than Lally, and he's 3 years younger than me.
Got a lot more hair.
It has to do with how authority works in the law. I can explain it, but it'll take a while. She doesn't have to follow the other states either. No. Yeah. But normally you would look at other states and say, okay, if one state have a precedent with this. Yeah. But if 20 out of the 52 states have a precedent with this, then you'll rely. Obama said there was 52 states in America.
Nope. Just 50.
Yes, he did.
Well, I believe that, but it's just 50. Till we get Greenland. Anyway, there's only 50.
And Canada.
Those are the 52, maybe.
So she would have to look at other states' laws, and again, if it's common practice in other states and not just it happened once before, then she will probably be more reliant. Maybe if it's been proved, if it's been tested in that state's Supreme Court. That's why she said the more. How did she say it? The more
authoritative, but that's not the right word. That's what it meant.
Yeah. The higher up in the system it has been approved, the better it is for you. The closer to Massachusetts, the more likely she'll accept it. Yeah, and again, if it's...
What the hell was the word she used? Convincing? Persuasive.
Convincing, persuasive, yeah.
That was it. The more persuasive, the better, she said. Meaning higher up is the way I took it.
There's actually only 46 states in the U.S. along with 4 Commonwealth.
Hey,
the White Rabbit doesn't like Commonwealths.
After this, why would you?
I don't. But I have no. I have no opinions on Commonwealths either way. I'm not racist. But
if they're all like Massachusetts, I'm gonna hard pass on that.
What are the 4 Commonwealths?
D.C. District of Columbia might be a Commonwealth, but that's not a state anyway, so that doesn't count. I wouldn't assume. I have no idea. Why don't we look it up? Which
didn't you have civics in school?
Bruh. The United States is bigger than Europe. Do you know everything about every country in Europe and its provinces?
I probably know a few more things about every country in Europe than you do about every state in America. I probably know more about most states in America than most Americans. Massachusetts,
Virginia,
Kentucky,
Massachusetts, and Pennsylvania. Virginia, Kentucky, Massachusetts, and Pennsylvania.
That's called poverty. If you live in uncommon wealth, that's poverty. No, it's Canada. That's how it's spelled. Have you set up your redirect?
Yeah, I think. I'm pretty sure. Let me double check real quick. I'm going to set up a goat stream right after this, y'all. So we'll go back to doing the live goat cam. I'm pretty sure I set it up.
I'm going to take a night and watch Yellowstone 1923. Yep. Pretty good series. What is Louisiana? A private kingdom? Well, it's bought from France, so it's probably
Louisiana
a bit smelly
Purchase.
and have weird music.
It used to be
Jemima, as a mod, you should listen. I said I'm going to do the closing arguments in the plow pew pew case tomorrow. This is my mod team. You have Zach on your mod team, and it's not even that bad.
Yeah, I'm good to go, man.
I'm sorry, Jemima. I still love you.
2024.
I'm getting so much trouble the second I log on.
Bakey's Mod of the Year recipient, 2024.
What exhibit are you referring to? I'm going to make this 100, Your Honor. All right. 100.
100.
Because it is 100%.
Correct.
Objection, Your Honor. So you literally built a cannon?
Yeah, it's pretty awesome.
Thank you, Lisbeth, for giving $5 to Valhalla's channel. Case law from Green and State would be interesting and a good argument.
Oh, that was the cutest thing I've ever seen.
Thank you, Liz.
For this. Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.